I want you to look at your screen. This graphic shows the difference between a living trust and a will. One avoids probate, the other doesn't. One is private, the other is public. One allows for incapacity management, the other is only effective at death. What does all that mean? Well, to give it to more context, we're joined by Theodora Vaporis, an attorney with Tuggle Duggins PA. So kind of let's lay it out there. What does a will do? What does a trust do?
So a will is a document I think people are more familiar with, right? You sign the will, it tells what will happen on your death with your assets, excuse me. It appoints a person to be the executor, to be in charge, and it sets out the disposition of your assets, who gets what. The downside of a will is that one, it's public, and two, you have to go through the probate administration process. So
which means it can take like a year or so before everything gets done.
With the court, and there's a lot of oversight.
Okay.
And for a lot of families, that's more than they need.
Okay.
So an alternative is a trust. There's all different kinds of trusts, but I think the one that we're referring to primarily right now is a revocable living trust. And the reason the word living is used is because it's established during your lifetime. And in that, it's a legal arrangement. You establish the rules of the trust. So you say within the trust what's going to happen during your life and what's going to happen during your death. Typically during your life, the trust only benefits you and your spouse, or you and your children. And then at your death, it works much like a will in that it sets out what should happen next. Oftentimes the trust continues. Perhaps you have a beneficiary who isn't good with money. So you want to keep the trust going so that they can benefit from it, but not have all the money at once. Maybe you have minor children, so you set out the rules within the trust, what will happen. Sometimes the trust just terminates at your death as well, and all the assets get distributed.
So, but couldn't you do that with a will? Couldn't you say, I don't want this person to get all of the money, I want them to do such and such?
So you can establish what we call a testamentary trust within a will, and that's a trust that goes into effect only at death. Oftentimes parents will set those up in their will for children, so if they die before a child is whatever age they think is appropriate, the trust terms are in the will, or a special needs trust for a person who has special needs. Just the difference is that it's public. The will itself is public. Also, when you have a living trust, let's say you set it up and then you start to age. Well, you are typically your own trustee, but there's another backup set up. So in the case for my family, my mom had one, and as she aged, she said, I think you should take over now as trustee. And so I managed her money, but she was still alive. And then upon her death, we distributed the assets the way that she said.
And again, the big deal is it doesn't have to go through probate, so you don't have to wait for a court or anybody to do anything with all of those assets.
That's correct, and it remains private within your family.
Okay, so what does putting your house in a trust do versus putting like your kids' names like on the deed of the house, or saying in the will, these kids get it?
Right. Well, most lawyers are not big fans of putting your children's name on the deed to the house, because once you do that, they own the house with you. And the consequence of that can be, well, what if your child goes through a divorce? Well, that house kind of gets brought into that. If your child goes through bankruptcy, if your child makes bad credit decisions, all of a sudden that house is at risk. So if the house is in a trust, then the trust terms arrange it, but that can't be attacked by your child's creditors.
Ah, okay, I understand. All right, now here's something that happens very often with a house. People will say, well, I want to leave it to all my kids because I want to be fair. And you say what about that?
I say it's a theme, and I understand the family land is important, and if there's a lot of land, sometimes that can work. But when you have one house and multiple children, typically conflict arises. We spend a lot of time in our legal practice doing these actions that we call partition actions. And that's because the kids can't decide what to do. And so it all ends up in court, and the court orders the sale. So one thing that you can do is put in your will or in your trust one person, the trustee, or one beneficiary who gets to sell the house and then distribute the assets.
And that way you put in
cleaner.
The parameters that they have to distribute the assets, so it's not like they can keep it for themselves.
Absolutely.
Okay.
Absolutely.
And is a trust more expensive to do than a will?
It is. It is. It is a little, it's probably twice the cost of a will, but you also have to think about the benefits long term, because you're not going to pay for the probate process later. It's just more efficient.
Okay, I understand. Thank you for giving all of that context. We appreciate it, because it's a complicated topic.
It is.
For sure.
It really
so thank
is.
you for your time and expertise.
You're
right
welcome.
now, what we're going to do is we're going to check a look at that forecast.